Not a bad thing.
They're huge.
Sometimes. I'll tell myself that.
I have friends that wanted to king officer or wanted to ski. Their food. I've actually never been there.
You found the
Good evening. I'd like to call to order the July 20th, 2026 Planning Commission meeting for New Kent County. If you would, please all rise for a moment of silence and our pledge to the flag. Please turn with me to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Mr. Ryder, could we have roll call, please?
Ms. Townsend,
Here.
Ms. Johnson,
Here.
Mr. Moyer,
Here.
Mr. Dombrowski,
Here.
Ms. Thomas,
Here.
Mr. La Rochelle,
Here.
Dr. Schmidt, Mr. Davis,
Here.
Ms. Rose,
Here.
Reverend Hathaway,
Here.
Mr. Bennett.
Here. We have a quorum. Thank you all for attending tonight. Item number 4 on our agenda is the approval of the minutes for the June 15th, 2026 regular meeting. Hope you all had a moment to peruse those, and if you have any additions, corrections, or deletions, let it be known. And if there are none, I'll hear a motion.
Mr. Chairman, if there's no corrections or changes or deletions, I suggest that we accept the minutes as presented.
Thank you, Ms. Townsend. The motion is to accept the June 15th regular meeting minutes. Roll call, please.
Ms. Townsend,
Aye.
Ms. Johnson, Mr. Moyer,
Aye.
Mr. Dombrowski,
Aye.
Ms. Thomas,
Aye.
Mr. La Rochelle,
Aye.
Mr. Davis,
Aye.
Ms. Rose,
Abstain.
Reverend Hathaway,
Aye.
Mr. Bennett.
Aye. The reason for Ms. Rose's abstention is that she was not present at the time. Item number 5 is citizen comment period. And this period of time is for those who'd like to speak before the commission on any topic other than those that are of public hearing tonight. You will have 3 minutes. And has anybody signed up? Okay. Thank you, Mr. Silva. Sarah Meredith. As you come to the podium, please state your name and your address, please.
Highway, Clinton, Virginia. I'm here to talk about the TOD. Yes, I understand that the Board of Supervisors recently passed a motion discontinuing further work on the TOD and expressed that it is no longer the policy direction of the board. However, I believe this process brought to light foundational issues in this county's government regarding accountability, transparency, and fairness. Therefore, the fact that the proposal is not moving forward in its presented form does not erase what the process revealed, nor does it stop us from learning from it. The specific issue with the TOD I want to bring up today is the county giving certain landowners special treatment. Publicly, residents were given the impression that the county had undertaken a land-based study focused on criteria like acreage, zoning, and proximity to utilities. But the county's internal documents revealed that a specific landowner received preferential treatment and specific landowners were excluded. I asked the county what policy authorized ownership to be used this way, and I did not receive a real answer. My concern was not simply that ownership was considered in some broad overarching sense. I want to be clear, the records showed specific named owner treatment. The ranking criteria explicitly stated that Jonathan Kinney-owned parcels received special consideration. Tidewater Foundation and Crisscross properties were excluded. Agricultural land was treated as ideal if owned by Jonathan Kinney. My concern was deepened when I reviewed other internal records that showed prior to the study's approval, a site connected to Jonathan Kinney, referred to as Kinney Tract 2, was already being discussed with data center developers. Those discussions included an NDA with Amazon concerning the site. The issue I'm raising today is not the existence of NDAs or conversations with developers. The issue is what it means when those types of conversations and agreements are happening before or alongside a planning process that is later presented to residents as a proactive countywide study. This issue raises a very basic question. Was the county neutrally studying land across the county, or was it working around a site that was already under consideration? That is why I'm still talking about the TOD today, even though the proposal itself is no longer moving forward, because the process still matters, accountability and transparency still matter, and residents still deserve clear answers about how this happened, what policies allowed it, whether this practice has been used before, and what safeguards exist going forward. So in conclusion, I'm asking the county to provide a full accounting of the TOD's development, including when the county began discussing particular sites with developers, how those discussions influenced the study, and what policy or authority permitted ownership to be used in that manner. And going forward, I'm asking this Planning Commission to insist that all future land use planning be conducted in a way that is fair, transparent, and fully understandable to the public as it's happening, not only after residents piece it together through FOIA. Thank you.
Thank you, Ms. Meredith. Having no other people or persons to sign on the sign-up sheet, I will close the citizen comment period. I'm sorry? Okay. We'll move ahead. Presentations. Our illustrious county attorney, Mr. Zhang.
Thank you, Mr. Chair. You're way too kind, though. Good afternoon, Mr. Chair, Vice Chair, and members of the Planning Commission. I'm thrilled to be here with you all today. I've been asked by the Board Chair and Vice Chair to give a brief high-level overview and presentation about how the Planning Commission should deliberate or approach its deliberations on public hearing items. This is just a high-level overview. Obviously, if there are any questions or any comments or feedback after this presentation today, I've asked to limit myself to 5 minutes. I'd be happy to return back and give these 5-minute educational series in your pre-6:30 public hearing items. So understand that I'm approaching this from the perspective of rezonings and special use permits applications before this body, and understand that the Planning Commission generally makes a recommendation to the Board of Supervisors rather than provide the final legislative decision. Hopefully for folks that might be tuning in today or might be here today, this might be of some use to provide that overview on the deliberations process. So before deliberating, commissioners should ask, especially upon receiving packets that staff provides and assembles together as a report, what does the ordinance require? What does the comprehensive plan recommend? What evidence supports or contradicts the application? And can identified impacts be addressed through lawful conditions or voluntary proffers? Generally, staff will provide some of their insight and guidance into the staff reports, but that doesn't give any reason for commissioners to be able to question those and ask thoughtful questions or follow-up issues based upon those reports or on the application. We want to be able to focus on legitimate land use considerations. So relevant considerations include the existing use and character of the surrounding area, the comprehensive plan, the suitability of the property for the proposed use, growth and development trends, transportation and traffic. So for some of the higher and more intense use that you guys hear before this body, it might be a requirement of the applicant to actually submit some sort of form of traffic study or a traffic impact analysis. Housing, schools, parks, public safety, and other public services. A consideration of natural resources, floodplains, agricultural or forestal lands, conservation of property and property values, and the most appropriate use of land throughout the locality. Sometimes you might hear the phrase saying the highest and best use for this particular parcel. The commission should distinguish between evidence-based impacts and generalized opposition. For example, I do not like apartments is not a strong land use reason. And I'm giving some of these examples. They're very basic. They're just meant to be high level. And I know you guys put in a lot of thought, a lot of sophisticated and thoughtful, wise decision-making in it. But I just want to be able to distinguish to you as a body and also the public that might be tuning in this contrast between what is a good, legitimate purpose versus what may not be. Another example, the proposed entrance does not meet the ordinance standard and creates a documented site distance concern. That is a legitimate land use reason. And that's something that you guys should feel comfortable and free to articulate that throughout your deliberations, particularly after the public comment period has ended. Neighbors oppose the project is not standing alone is sufficient analysis. It could be part of your decision-making, but that as a standalone should not be the only reason. Testimony identifies noise, traffic, drainage, compatibility, or safety impacts that relate to ordinance criteria that may be properly considered. You can cite to that as you're coming up with your position and ultimately your vote and recommendation as a body. Public comments are made part of the record, but the commission must evaluate their relevance and weight rather than treating the number of speakers as a referendum. Another point, and this all kind of comes to head because we want to ultimately be able to build a defensible record. That's like the most attorney thing to say. I'm an attorney, so that's why I'm saying it, right? Virginia courts generally defer to legislative land use decisions when the issue is what we call fairly debatable. Now, obviously, everyone here has an idea of what fairly debatable is. It carries what we call a legal term of art. There have been case law, case decisions that have come down through decades that kind of define what this means. But in the very simplest aspect of it, it just means that objective and reasonable people could reach different conclusions based on the evidence. So one side of folks might be able to say, I oppose this project for these reasons. Other side might say, we approve it for these other reasons. That's what we call a fairly debatable standard. It's a deferential approach that the courts give to the Planning Commission and to the governing body throughout its legislative process. I'm going to skip on some of the court cases here, but there's one court case that was decided in 2023 where the Court of Appeals ultimately upheld the denial of a special exception. That's one of the particular uses. I don't think this county currently hears special exceptions, but for some localities they do, and it requires a legislative process just like a SUP, a CUP, or a rezoning. But the court found that the governing body and the Planning Commission weighed the staff report well. They weighed the public comments, its knowledge of the local conditions, and the evidence. They cited to the evidence concerning noise, traffic, and neighborhood character in its denial. And the court ultimately upheld it because they found that this met the fairly debatable standard. There is another case from several years, actually decades ago, where the Supreme Court of Virginia actually reversed a land use decision. In this case, it was not necessarily a rezoning or special use permit. It actually dealt with historical features. So there was actually a case where a city council compelled a property owner to reinstall wooden doors in a historically significant district, thinking that the house, the property at the time, always had a wooden door dating back to when it was constructed in like the 1880s. And at the trial court, the property owner was able to prove that the city did not actually have any probative or any, I would say, threshold matter to even prove that there was even a wooden door at that property at that time. So at that lowest threshold, the probative value of it, the city was unreasonable in its decision to compel it. And that's something that we want to be able to cite as guidance to this honorable body because you want to be able to have this evidence-based criteria as you guys are making your decisions, as you guys are debating the merits of the application and ultimately coming up with a vote and your recommendation. So what does this all have to say? This all has to say that commissioners should review the staff report and relevant materials before each meeting, ask the questions on the record, identify the particular ordinance or plan provisions being applied, explain why competing evidence is persuasive or unpersuasive, and avoid relying on speculation, personal disputes, or unrelated conduct. I wanted to also mention why we should treat conditions and proffers carefully. Conditions should address impacts attributable to the proposed use, and they're authorized by the ordinance and be sufficiently clear to administer and to enforce. So for rezonings, proffers must remain voluntary and satisfy applicable Virginia law. There was actually a case law where it explained that a locality must evaluate the merits of the entire application and may not require a particular proffer as a prerequisite to approving or denying the rezoning. proffered conditions must have a reasonable relationship to impacts arising from the rezoning and conform to the comprehensive plan. So moving on to the motions aspect of it. You guys have already deliberated and discussed, so now it's time for the motions. A good motion should contain 4 elements. 1, identify the application. 2, state approval, denial, or deferral. 3, identify the governing standards and principal reasons. And then 4, incorporate the applicable conditions, proffers, or staff materials. So I'm just going to give you an example motion, and also there's standard golden rule language that we like to say, it's for the general welfare, best interest of the public, and whatnot. I have a little bit of a different motion, but there's not one size that fits all. But an example motion to recommend approval is I move that the Planning Commission recommend approval of this application, cite the number, subject to the conditions stated this time, and voluntary proffers because the application is consistent with the comprehensive plan and applicable zoning ordinance criteria, and because the record demonstrates that its transportation compatibility, environmental, public service impacts have been adequately addressed. So each one is going to be a bit different, right? Having a big multifamily rezoning will speak to certain transportation and traffic impacts. Other rezonings might be a bit different. But this is just an example. A good example of a motion to recommend denial, I move that the Planning Commission recommend denial of application number because the application does not satisfy the applicable approval criteria specifically and identify that criteria, and because the record demonstrates this impact, including this traffic incompatibility, drainage, public service, environmental, or any other documented concerns. And for your denial, I generally recommend that you identify 2 or 3 specific reasons rather than only saying it is not in the county's best interest. I'm going to skip on the motion to defer. That's generally when the applicant requests before this body because there might be some information or feedback they've received from a community meeting that they want to go back and look into their application and reevaluate and come back before this board. But oftentimes, if the Planning Commission, if there is a certain aspect of the application or a question before this body that hasn't been sufficiently addressed, that you can put forward a motion to defer the application to a future date. So in closing, the safest practice can be summarized in 1 sentence. Make the decision on the application that's actually before you. Apply the standards that actually govern it, and state reasons that are actually supported by the record. A commissioner may disagree with staff, the applicant, or the public, but the recommendation should always be traceable to lawful criteria and evidence, not popularity, speculation, or personal preference. Thank you very much, Mr. Chair.
Any questions for Mr. Zhang?
I have a question.
Yes, ma'am.
Okay. My question is this. The information that is presented before us, and I'll give you the perfect example. Last month, when I came in here last month, I had no clue of all of the things that were happening because I'm a rather busy woman. But that being said, once I took a look at the application, I had my questions earlier that week when I started to review because I was actually looking at site plans. And being that I'm in the technology business, I understand site plans very well.
Sure.
Okay. That being said, once I came in here, I started listening to the information that was presented, what the applicant said. I had even more questions. Okay. So with my vote, I can honestly say, with my vote, I placed my vote on what I believe was right based on the evidence that was before me.
Great.
Unbeknownst to me, 3 days later, I'm standing in the grocery store and I get a slew of information that I had no idea about. Now, that being said, I don't believe everything that's online. Because when people know who we are, we can be in the grocery store and people will stop us.
Sure, yeah.
But absolutely. Once I saw for myself the FOIA requests that are all the emails that are all online about what is happening with the applications and the things that's happening, and the conversations that are being had about data centers with our applicant, what does that do for me? I've been an applicant before, and I was put through all types of tests, all types of accusations. All of this is public record. But yet, I'm reading emails, FOIA requests. These are things that are not made up. These are things that I've read with my own eyes and saw it. And I'm being asked now, I'm being asked what? Not to speak, I don't understand that when I can see the conversations that are happening with FOIA requests, the applicant didn't disclose it. The planning department never said anything about none of this. I had to find out by reading all of the things that citizens in this county gave me in the grocery store, and I said, okay, if they're saying something about FOIA requests, let me read it. So I want to make that clear on the record. Not when I vote on things, especially when it comes to technology, I'm very good at what I do. I'll pat my own self on the back. However, when I see evidence before me that's not adding up, I'm going to vote the way I believe is right, not only for me, but for the citizens in this county.
Absolutely. Commissioner Thomas, I think when all members of this body are appointed by the Board of Supervisors, everyone brings a unique skill set. In yours, it's technology, and I believe you run businesses, so you have a business acumen that brings into it. And ultimately, when you get the staff report and the application before you all, you have absolutely every right to make an independent decision, independent review and study of the materials as you are considering the application before you all. I think regarding FOIA, there might be some pertinence or factor that goes into your decision making. That's your every right to make that independent decision making. Absolutely, Commissioner Thomas. But
I want to be clear.
Go ahead.
That information wasn't presented to me. I saw it afterwards. I made my professional decision based on what was in front of me. But my point today is you're saying the evidence that is put in front of us, right?
Yes, ma'am.
We are supposed to weigh it with the evidence that is put before us. What was put before us, I reviewed it based on my knowledge, my professional knowledge.
Great.
However, seeing all of the conversations and the communications that were happening in the background, when we were told there's nothing about data centers. There's not. But once I started reading all of the FOIA emails, it doesn't look that way at all. And this is why I'm choosing to speak today, because you're presenting this, and I want to go on record to say I made my decision based on that site plan that's sit in front of me.
Gotcha. Well, thank you.
Mr. Zhang, on
Yes,
FOIA
Mr.
requests, isn't that private communication between the questionnaire and the respondent?
Well, it's public records.
I understand it's public record, but the actual communication is a private communication, is it not? Or is it a public?
It depends,
Okay.
which is a common lawyer refrain, right? They are communications with a public official that are generally treated as public records. Now, what you might not see, Mr. Chair, is that every FOIA request goes into a particular land use application. That's not expected of it. But given what Commissioner Thomas has said, given a lot of the conversations around the community, commissioners, you go all to the grocery stores, to the county fairs, you see folks. I mean, generally planning commissioners, even in my private land use practice experience, you guys are like the front lines, right? It's impossible to ask of any commissioner not to weigh that input into it, which is fair game. But, a lot of the probative decision-making is not only just based on your independent decision-making and fact-finding, but also with the relevance of the application before you all at a particular time. So, that's all you have to weigh. It's a totality of the circumstances. And I think any governing body could just only ask that their appointed planning commissioners do their best and weigh the evidence that's before them and evidence that they may hear about around town. Your emails are public info. I think citizens are welcome to always provide their feedback to planning commissioners. That's just part of the public input process. And that's ultimately what grounds in the legal standard of this fairly debatable standard.
Any other questions?
Mr. Chairman,
Yes,
thank
sir.
you, sir. I'd like to summarize. So obviously, the information that's presented to us in the planning pack or in the agenda in the planning pack, that's part of our decision maker. We want to consider that. Want to consider public speakers, consider what the applicant may present, but we're also allowed to bring our experiences as we go through life. You develop experiences, develop opinions, develop ideas about whatever the topic may be. That's allowed to be part of the consideration as well.
Well, sure, especially in your questioning to the applicant based on your skill set. You may know something from Dominion Energy that I certainly don't know about. So, absolutely, sir.
Thank you.
Thank you, sir. And your next topic?
Next topic is AFDs.
Yes,
Thank you,
certainly.
guys.
We'll try to get that in here now.
Alrighty. Good evening, members of the board, or the commission. Sorry about that. For the record, my name is Patrick Silva, principal planner with the county's planning division. And to kick things off tonight, don't need the presentation quite yet, thankfully, but since it has been a little while since this commission has considered AFD-related items, I wanted to provide a quick refresher and overview of the AFD program in general, and key points to keep in mind as you consider the withdrawal district renewal and additional requests before you this evening. So in establishing the AFD Act, which allows localities to adopt regulations and a framework for local AFD programs, Section 15.2, 4301 of the Virginia State Code establishes that the purposes of such programs should be to conserve and protect and encourage the development and improvement of the Commonwealth's agricultural and forestal lands for the production of food and other agricultural forestal products. It is also the policy of the Commonwealth to conduct and conserve and protect agricultural and forestal lands as valued natural and ecological resources, which provide essential open spaces for clean air sheds, watershed protection, and wildlife habitat, as well as for aesthetic purposes. So as you all are aware, New Kent has for many years had an AFD program on the books, and it is quite robust. There are currently 19 agricultural and forestal districts across the county, encompassing approximately 42,351 acres, or approximately 29.8% of the county's total land area. So it is not an insignificant amount of land that is in the AFD here in the county. So it's certainly a very valuable tool in maintaining the rural character of the county, as is one of the core objectives in the adopted comprehensive plan. So speaking a little bit to the benefits to property owners of having their property enrolled in the AFD, they are actually numerous, despite the most well-known, of course, being that qualifying properties are granted use value taxation. So while AFD-enrolled properties still get the same tax rate as everyone else, the difference is that they get a market assessment and a use assessment, and the owners pay taxes on that use assessment. So qualifying properties enrolled in an AFD get a different price per acre value depending on the given use that is established there, whether it be agricultural, pastoral, or forestry. And it is worth noting that the Tax Code of Virginia does also set minimum acreage figures required in order to benefit from the use value taxation. So in the context of AFDs, these minimums are 5 acres for agricultural pastoral uses and 20 acres for forestal uses. However, contiguous real estate titled in the exact same ownership may be used to cumulatively meet these minimum acreage requirements. That'll come into play with, I believe it's AFD 4 on the agenda this evening, where the owner does have property that is less than either of those totals, but it's immediately adjacent to 50 some odd acre tract that is already in the AFD titled in the exact same ownership. So that's an example of how that can work. So the per acre value of property that's not enrolled in an AFD does vary considerably based on a number of factors. So this can include everything like from location to zoning, parcel size, topography, even market activity. And because of these variables, there's no standard per acre value that applies to all non-AFD properties. But Commissioner of Revenue staff has provided as a very general imperfect estimate that unimproved property that fully qualifies for AFD use value assessment could see their taxable value of its qualifying land reduced by approximately 65 to 75% compared to its fair market assessment. So certainly something that is desirable for property owners and also helps to conserve that land and, therefore conserve the rural character of the county. However, it is worth noting again, that's only a very rough estimate intended to provide a general sense of the program's potential benefit. The actual reduction can vary very significantly from one property to another, depending on the specific characteristics of the land, its fair market value, and the applicable applicable use value assessment. Pardon me. Consequently, the resulting tax savings may be higher or lower than that estimate. In addition, some of the other benefits of enrolling property in AFD is AFD enrollment can shield standard farming and forestry operations from certain changes in local zoning ordinances and nuisance lawsuits like complaints about noise, dust, or odors under the state's right to farm protections. They can also provide special eminent domain protections. For example, if your land that is enrolled in an AFD is targeted for infrastructure, like power lines or roadways, enrollment in an AFD can trigger a special elevated public review and state approval process before the land can be acquired. Perhaps most generally, enrolling land in an AFD can implement development restrictions, as by enrolling in an AFD, landowners implicitly agree not to convert the enrolled property to commercial, industrial, or dense residential uses. So this does also prevent non-agricultural development in the immediate area, thereby again preserving the rural character of the region. So while certainly the tax savings is the most popular and attractive reason to enroll for a lot of folks, there are other reasons and benefits to enroll in the AFD program as a way to conserve rural character and agriculturally viable land. So a little bit changing gears. In your all's role as planning commissioners, there are 4 types of AFD cases which have the potential to come before you for consideration. So these would include district creations. We don't see so many of these anymore, considering that there are 19 districts across the county, and most properties are located close enough to one that they can just join that district rather than create a new one. We don't have any of those on this evening, for example, but there are also district renewals, additions to existing districts, and withdrawals from existing districts. Again, we have no such request for a creation of a new district on this evening's docket, but in general, to create a district, an agricultural forestry core of no less than 200 acres, either in one parcel or contiguous parcels, must be established. Additional parcels not in that core may be included in a district if 1, the nearest boundary of the parcel is within 1 mile boundary of the core, 2, if it is contiguous to a parcel in the district, the nearest boundary of which is with 1 mile of the boundary of the core, or 3, if the local governing body finds, in this case the Board of Supervisors in consultation with the AFD Advisory Committee and Planning Commission, that a parcel not part of the core or within 1 mile of the boundary of the core contains agriculturally or forestrally significant land. So there is a lot of flexibility with respect to the ability to include a new parcel in a district under those 3 sort of scenarios. So requests to add additional property to an existing district must meet those aforementioned qualifiers, as well as be considered in relation to the criteria for evaluating an addition application under Section 62-36 of the County Code. You should have all been provided a copy of that in front of you this evening, which is kind of a criteria for evaluating an application section that is quite literally word for word, verbatim taken from the state code section on AFDs. And so that kind of outlines what you as commissioners are able to consider when looking at an addition request. It is, a lot of people are surprised to find out that it's a little bit more broad than you might expect. For example, not only existing agricultural or forestry activities, but compliance with the comprehensive plan, nearby agricultural or forestry activities, the impact of conserving that land, or environmental impact of conserving that land. These are all things that can also be taken into account under both state and local code. So for requests to withdraw land currently enrolled in an AFD prior to the expiration of a given district's renewal period, such cases are required to be reviewed and approved by the board, and should they be approved, such withdrawals are subject to 5 years of rollback taxes. So that's a little bit different than a case in which a property owner elects to not renew enrollment of their given property in an AFD during its renewal year. Those circumstances, so for example, we have 2 renewal requests before us this evening for Cooks Mill and Allen's Run. At the time that the AFD Advisory Committee, Planning Commission, and Board considers renewal requests, that's kind of in a, for lack of a better turn of phrase, eject button opportunity for property owners who wish to discontinue enrollment in the program while not also being subject to the rollback taxes. Obviously, we don't want, as much as possible, people taking advantage of the program, and as a means to maintain its integrity. That's a kind of way to encourage that. If people are entering the, an existing district or establishing a new district, that kind of gets them to continue enrollment of the property for the full term of that district, rather than just withdrawing willy-nilly with no penalty. So those rollback taxes do kind of provide an additional safeguard to superfluous withdrawals. In any case, that's about the long and short of it, but please feel free to pose any questions or concerns you might have either right now or as we're going through the process this evening. We just thought this might be valuable since we, in most cases, really only see these requests once a year. So with all that fresh in your brain, that may help in this evening's deliberation. So I will end my spiel there.
Thank you, Mr. Silva. Questions for Mr. Silva, and I believe Ms. Rose, you have a question or two.
Yes, sir. I had I think it's a quick question.
Okay.
It's concerning a couple of the renewals, where in both cases I think there was one particular property owner that did not respond. Does that end up being an automatic ejection?
It's actually the opposite. It's an automatic inclusion if we don't hear from them.
Okay.
There's not a lot of explicit state-level guidance on, whether localities have to treat those circumstances a specific way. And I will knock on wood and say I very much hope to have responses from those two individuals prior to going to the board. They have proven challenging to get in touch with. But if we do not receive a response, enrollment would actually automatically be renewed.
Okay. And is there, I guess part B of the question, is there a drop dead point? Is it once you've gone to the board and acted on it, then they, if you receive a response sometime after that point, they couldn't do anything about it for?
At that point, it is challenging. The ordinance would have been signed by the board that does renew the district with those folks included, so they effectively would have been included in that renewal. And at that point, I think it would warrant a withdrawal. Now, that being said, not to get too in the weeds on it, if someone were to file a withdrawal request shortly after that renewal, they really wouldn't have to pay the rollback taxes beyond the district period. That would have. So, I don't. Conceivably wouldn't present a big financial issue if we were to receive a withdrawal request shortly thereafter. But again, as a standard of practice, we very much like, as was the case last year, to have responses from everybody.
Yeah. Okay.
And if that means sending additional letters or even going and knocking on doors, that's certainly something we can do.
Mr. Davis, and then Reverend Hathaway. I see his finger first, sir.
Sorry. Like a game show, right? Mr. Silva, so an AFD property owner, if that person decides to withdraw to rezone or apply to rezone, can they make application to rezone, or they have to formally withdraw from the AFD before the rezone? Obviously, it's something other than A1 or conservation.
We would generally ask that before any land use request be made for a property within the AFD, that be withdrawn to allow those requests to proceed. Right. There are some allowances the state code makes, for example, this will be pertinent for this evening's withdrawal request actually, where the state code does provide allowances for, specifically in the case of family subdivisions, they kind of phrase it as gift or sale of a portion or of land currently within the AFD to immediate family does not in and of itself warrant withdrawal from the program. There are, however, at the local level, additional requirements that come into play that require any land to be subdivided, regardless of process or AFD status, to be withdrawn prior to that subdivision taking place, which is actually the origin of this withdrawal request before you this evening. They're looking to execute a family subdivision to give 2 parcels to their daughters.
And I believe didn't New Kent, enact an ordinance, I think it was related to the rollback taxes if it's a family subdivision, if you're withdrawn, that you're not subject to rollback? Or is that not? There was a change several years ago but I can't recall exactly what it is. But
Off the top of my head, I am not
yeah,
familiar.
I was the subject prior to that. Yeah, I paid rollback taxes.
That's a good question. The uniqueness of any applicability of rollback taxes as it relates to family subdivisions in specific, I might need to double check on with the Commissioner of Revenue's office. I don't have that clearly in front of me right now per se, but.
Let's pass it to Reverend Hathaway by Mr. Aragi. Maybe looks for the answer to your question. Okay, Reverend Hathaway.
Thanks, Mr. Chairman. Just for clarification, if there is a property owner that has property that adjoins an AFD, is there a minimum requirement, assuming that they meet the usage, is there a minimum acreage requirement?
So in order to, for the purposes of meeting those minimum acreage requirements in order to get the use value tax benefit, you would need to either meet that 5-acre minimum for ag or 20-acre minimum for forestry. And contiguous individual properties that may not qualify for that on their own can be applied for in tandem or after the fact, as long as there is adjacent property that is currently in the AFD that is owned by the same owner, and between those two properties, they are able to meet those minimums. Correct. Yeah.
Thank you, Reverend Hathaway.
No, I'm sorry, Mr. Chairman.
Sure.
One follow-up.
Mr.
Mr. Silva, and I guess for clarification as well, so this commission or the AFD board and this commission and the board of supervisors approve AFD parcels, the parcels to be included in the AFD, but it's the Commissioner of Revenue determines the actual acreage and also the confirmation of the agricultural or forest use.
Correct. Yeah, and they do have to verify that annually. Any property owners who have property in an AFD do have to verify that with the Commissioner of Revenue annually.
Right. Okay. Thank you.
Mr. Chairman, could you,
Yes, sir.
Could you please restate at the beginning you gave the total acres and the percentage of land,
Mhm.
county land? Could you restate that, please?
Currently in the AFD program, there's approximately 42,351 acres, or approximately 29.8% of the county's total land area. Yes, sir.
Thank you.
Ms. Thomas, Ms. Johnson, or Mr. Dombrowski, any questions? Mr. Aragi, have you been able to research that in the short time that we've provided you? Okay. Let's allow staff to have a
Yeah,
little
I'm
time.
fine.
Okay.
Yes.
Okay. No other questions. We'll move on to item number 7, which is old business. And I'm afraid I'm going to interrupt one of the two of you here because I got a couple items that maybe you could fill us in a little bit on. Item number 1, Pine Fork Ridge timeline. My understanding is that has been deferred a second time before the board. Is that correct? And what is the timeline that they'll be here before the board? I know it's been at their request, at least my understanding is at their request. But are they running out of a timeline, or what is the new timeline?
So you're correct. The Pine Fork Ridge rezoning request was originally slated after one deferral request from June to July. The applicant then again requested a second deferral from the July to the August regular business meeting. They are currently docketed for that August meeting. We have heard no correspondence from the applicant indicating that they intend to defer again. So for all intents and purposes, staff's understanding and anticipated date for that moving forward to the board for final consideration would be at their August regular business meeting.
At what period of time would they have to reapply? I mean, I'm sure they don't have an indefinite supply of deferrals.
Mm-hmm.
At what point in time would they have to reapply, if there is?
Based on the sort of zoning code timelines for when an item would have to be considered after application, they're not running up. I don't have the exact deadline in front of me per se. I'm not remembering what their original application date was, but they do have a number of months before they're even approaching that date. So certainly they're not in danger of needing to reapply if they were to be deferred again for another month or something like that, as an example.
Second item I have for old business is, having watched the Board of Supervisors and their actions regarding the Technology Overlay District, the next step is what? And I'm not trying to put anybody on the spot. I'm just understanding what we can foresee as a timeline towards some type of resolution.
You are perfectly fine just jumping ahead, and I was going to give that update at the staff report section later in the agenda. But yeah, so basically the board at their July 13th regular meeting took unanimous action to do two things. One, they directed county staff and the Planning Commission to discontinue the development of the proposed technology overlay district as a framework for data center regulation. They also declared the strong policy preference that no data center applications be filed or advanced as the county develops regulations and standards for data centers. Again, we have not received any. We have none in for consideration. So that is a policy preference that none be applied for. Moving forward, our intent is to still draft the performance standards for data centers. That includes strict performance standards, which Ms. Pearson, Supervisor Pearson, had mentioned at her or during her talking points during the June regular meeting, and have since been echoed by other board members. It also includes a project-specific public hearing process, such as a conditional use permit. That draft ordinance right now is planned to be presented to the board at their September work session, which is scheduled for September 29th, 2026 at 9 o'clock here in this room. Future community meetings and the ultimate required public hearings would be scheduled sometime after that work session and once initial feedback from the board is received. So our intent is to present this to the Board of Supervisors, since they have given us direction on things to consider and include in that ordinance draft. We would then ask at that same meeting, most likely for one, their feedback, and two, a resolution sending the new draft to the Planning Commission for further review and refinement. So you guys will still have an opportunity ahead of any public hearings to weigh in, comment on that, and kind of refine the standards that are drafted.
Thank you. Another item is the zoning ordinance rewrite reconsideration. I know I'm robbing your fury here, but to me, they're old items. They're just continuing items.
Mm-hmm. Yeah, so regarding the overall zoning and subdivision ordinance update project, I don't have a major update for you guys. The Berkeley Group did present the findings of the diagnostic report and the community feedback and all the engagement that surrounded that at the board's June 29th work session. Since then, we've provided some contextual clarifications on specific questions the Berkeley Group has had as they start reorganizing and restructuring the ordinance to include, one, a new format, and two, the state-required language. The next joint work session will most likely be in November. That's tentatively scheduled right now, where planned topics include the restructured ordinance, a review and discussion on the Code of Virginia items, and an initial policy discussion before we really get into the meat of the project, where we're looking at what exists now and how we want to change items.
Okay, thank you. Any other old business before, for the staff? Reverend Hathaway.
Again, clarification. Will there be a committee working with staff and the consultant?
For the overall update?
Right.
The intent is to do the joint work session. So we had the joint kickoff session in June. November will be another joint work session between Planning Commission and the Board of Supervisors. And then there will be several, I think another 4 or 5 throughout 2027, where we'll be bringing pieces to you guys for consideration. There's also future community engagement opportunities that are planned. There's a project website where all the drafts will be posted. I believe our consultant is looking into a digital kind of comment platform where citizens can provide comments on the draft language as we go along, but not a definitive specific committee like they had in 2008.
Reverend Hathaway, are you suggesting that maybe there be a planning commission work session for each subsection of the ordinance rewrite?
I really do believe the Planning Commission needs to have a little bit more input as we develop the process. It's very difficult in a joint meeting to really dig deep into the issues. So my sense is that we really need to have a work session. I'm not saying every month,
Understand?
clearly.
Yeah.
But at certain points in this process, we should have a work session to look at it.
Any discussion on that?
I agree
Mr.
with
Chairman,
that.
I'll agree with that as well.
I agree.
Okay.
Okay, we will take that back to the consultant and talk through what that looks like and how that fits in the current budgeted scope, and we can report back at a future meeting.
Thank you very much.
Could I?
Yeah, I'm sorry. Yes, Ms. Rose.
One quick thing during the joint work session where they presented the information, they mentioned a number of matrices that they created, taking our existing ordinance, all the cross references and the legal basis. Is there a point in time, kind of early on in the process, where we could get copies of those?
They should have been included in the packets. They're also posted to the project website.
They are
Yeah,
Okay.
they should be under the documents and resources section. So that
Okay.
should include the diagnostic report, which should have the matrices in it, along with the community engagement summary.
Okay.
So that'll be the kind of pre-filled selectable answers along with any comments that were received throughout the surveys, the pop-ups, things like that.
Okay. Is there a way to get get those matrices in like Excel or?
I can certainly check on that.
Because I love Excel and I like being able to search and sort and.
Yeah, I believe the
it
final
makes
product
the
was.
review
I believe the final product for presentation purposes was PDF format,
Yeah.
but we can certainly check to see if they'll share the Excel document with us.
Okay.
Can't get it in a spreadsheet.
I know.
Yes, sir, Mr. LaRochelle.
Thank you, Mr. Chairman. So regarding the second motion from the Board of Supervisors meeting about not accepting applications, and I don't know if this is a question for the county attorney, but can we legally say we're closed for business?
You said the word legally, so I'm going to turn it over to County Attorney.
Thanks, Mr. Chair. Thanks, Mr. Aragi. The answer to your question is that if one were to apply and submit an application, we cannot legally close off and say we're pushing your application to the side and let it gather dust. It must continue to go through the ordinary process. But I think throughout all stages on the pre-application stage, particularly as the developers are having conversations with county staff, they will reiterate the strong policy preference of what the board has reiterated. And also, subject to any review period, as you can imagine, county staff will be taking time developing specific performance standards. And if there is a developer that decides to push through with a proposal, staff has to be able to weigh what they are currently developing against the application they receive, particularly the comments and feedback they have to engender as they go through the process. So it's a strong policy preference that's stated by the board, but any applications will continue to go through whatever process under staff's review through the public process.
Okay, so thank you. So if we wanted to leave that strong policy preference in place indefinitely, I mean, it sounds like it's not really, we haven't closed the door. We're signaling where we don't want you to submit. We can't force them not to submit.
Correct.
But an astute applicant would realize they're going to be swimming upstream at this point.
Mm-hmm.
But legally, they can submit and insist that it go through the process, and we can't stop that, right? Even with that motion that was made, that doesn't stop applications.
It doesn't stop the application from being submitted, developed by staff. It doesn't certainly stop this commission if it feels like that the application, and of course we're talking about speculation, but assuming that everyone is aware that there's specific performance standards being developed through it, whatever application or whatever developer will come in, they're kind of shooting into the dark or shooting from the hip in terms of what conditions or what proffers, if it is a rezoning, that they would propose. Remember, this is a public process, so this body gets to hear that application on its merits and forwards a recommendation to the board level. So there's no by right use, There's no, golden hand or golden ticket to approval. It would still have to be subject to a rigorous, and I have a hunch, a very fairly scrutinized review process, public process. So it's up to them. It's a buyer's beware. So.
Thank you.
Any other questions? If not, I'm going to move to item number 7, new business. And I'm looking at Mr. Silva or Mr. Raggi. None. Okay. Moving on. I'm sorry, that's item number 8. Number 9 is public hearings, and I will turn the floor over to Ms. Rose.
Thank you, Mr. Chairman. Good evening, ladies and gentlemen. Tonight we have 9 public hearings before us. Each has been properly advertised for tonight's consideration. Let me take a moment to review the procedures that we will use for tonight's hearings. Each public hearing will be considered separately. Staff will give a brief overview of the hearing that is before us. The sponsor of the case will be given an opportunity to make a presentation. Commissioners will be given an opportunity to ask questions of the sponsors or staff for clarification purposes. I will then open the citizens' comment portion of the public hearing and receive your comments. Sign-up sheets are located on the desk by the front doors of the admin building. I ask the following. You come to the podium, state your name and address for the record, address your comments to the commission, limit your comments to 3 minutes, please. When the timer sounds, please conclude your remarks. I'll now open the first public hearing, application AFD-01-26, withdrawal from Upper Chickahominy AFD.
Thank you very much. And I know we've got a long agenda, so I'll waste no time and just hop right in. So again, the first item docketed for consideration this evening is a request to withdraw tax map 7-3, a 166.25-acre parcel located at 9950 Peace Road from the Upper Chickahominy AFD. This was submitted by applicants William F. and Rhonda K. Gifford, Jr., and a copy of the application and supporting documentation was included in the meeting packet for this evening's meeting. So a little contextual information first. The Upper Chickahominy AFD currently consists of 18 parcels, totaling approximately 1,417 acres, and is currently not set to expire until August 31st, 2028. The Upper Chickahominy AFD is located in the far eastern portion of the county, along the shared county line with Hanover and Henrico. Most of the district parcels lie to the north of Quaker Road, with approximately 6 district parcels located south of Quaker Road. The subject parcel on this request is located along the south side of Peace Road, approximately 650 feet north of the intersection of Quaker and Peace. Now, the landowners wish to withdraw this parcel in order to execute a family subdivision and gift one 10.9-acre parcel and one 6.2-acre parcel, both located along Peace Road, just north of its intersection with Quaker, to their 2 daughters, who will not continue actively using the land for agricultural or forestry purposes. I mentioned earlier this evening, the state code does contain provisions that do allow for municipalities to adopt regulations which exempt the need to withdraw land from an AFD in the case of a family subdivision. However, it is section 91-10C of our local code that does require this to take place, as it states that, quote, lands within an agricultural and forestal district as established under Chapter 62, special districts, must be withdrawn in full accord with established requirements prior to being subdivided. The applicants do have the right to withdraw from the AFD program. An Agricultural and Forestal District Advisory Committee recommendation relating to the withdrawal request was required pursuant to New Kent County Code. Due to the request to withdraw from the Upper Chickahominy AFD prior to its August 2028 expiration date, the applicant would be subject to 5 years of rollback taxes on the land pursuant to the Code of Virginia. In conclusion, AFD Advisory Committee did review this request at their June 25th meeting and unanimously voted to forward a favorable recommendation of approval to the Planning Commission and Board of Supervisors. And that concludes my presentation on this one, but happy to answer any questions you all may have.
Mr. Chairman, what does that do to the properties adjacent to it? Because you usually join based upon that property was already in the center.
It's a great question, and this exact same like topic area came up at the AFD Advisory Committee meeting. Staff did confirm that all other parcels surrounding it, which are even located further south of the core than this one was, would continue to comply with all of those distance qualifiers, whether it be located within 1 mile of the core, located within 1 mile of an existing boundary of a core. All of those surrounding parcels, their enrollment in AFD would not be jeopardized by removing this parcel.
One question. Mr. Chair. Oh, Mr. Chair. The rollback taxes is rolling it back from the use tax to the regular agriculture.
The sort of market value, yeah.
Going to market value. Okay,
Yeah.
very good.
Any other question?
Yes, Madam Chair.
Yes.
So, Mr. Silva, as far as reading the recommendation, says they will not be able to rejoin the AFD program. Just means they won't be able to rejoin the AFD program within, is it 1 year or when the AFD itself renews?
So the parcel itself would not be ineligible to rejoin the program. Maybe could it be have been in like specific reference to the parcels to be created via family subdivision?
It's in the second paragraph of the recommendation. They also understand they must pay all associated rollback taxes related to the early withdrawal based on current tax code and may not be able to rejoin the AFD program.
So that's a kind of perhaps phrasing faux pas. Not to say they would not be able to, but understanding that in certain circumstances, the withdrawal for the purpose of subdividing land may result in a configuration where the land you have at the end of that subdivision may be ineligible to join. So no specific comment on this request, but in general, we do warn all applicants withdrawing land that has the possibility to happen depending on what's proposed.
Okay, so the shape and configuration of the parcel, if it's not within that 1 mile of the next adjacent, or if it's not immediately adjacent.
Correct.
Then,
Yep.
Okay, I understand that.
Yep.
Okay. All right, thank you.
So I admit that could have been phrased better, but that's not meant to say in this specific case they would not be able to rejoin.
Right. Okay,
Yeah.
thank you.
Yes, Mr. LaRochelle.
Madam Chair. So the maximum rollback, and this is more of a general question, the maximum rollback on taxes is 5 years. So if you get in to the AFD when it's created and you withdraw at 8 years before the AFD renews, you only pay taxes for 5 years? The rollback is a max of 5 years?
That's my understanding, correct. You'll have to forgive me, the tax area of everything is not quite my expertise, but that is my understanding.
Any other questions? Can we look at the sign-up sheet, please? Let the record show that no one has signed up to speak. I will now close the public hearing and turn it back over to the chairman.
Thank you, Ms. Rose. Any discussion among the commissioners? I will entertain a motion.
Yes, I would like to make a motion.
Yes, Ms. Thompson.
In order to address, protect, and promote public convenience, necessity, general welfare, and good zoning practices in the county, I move to adopt Resolution PC 08-26 to forward application AFD-01-26 to the New Kent County Board of Supervisors with a favorable recommendation.
Thank you. Recommendation is to forward a favorable recommendation for AFD 0126. Final discussion, if any. If not, I will ask for a roll call. Mr. Reimer?
Ms. Townsend?
Aye.
Ms. Johnson?
Aye.
Mr. Moyer?
Abstain.
Mr. Dombrowski?
Aye.
Ms. Thomas?
Aye.
Mr. LaRochelle?
Aye.
Mr. Davis?
Aye.
Ms. Rose?
Aye.
Reverend Hathaway?
Aye.
Mr. Bennett?
Aye. Thank you. Ms. Rose?
Thank you, Mr. Chair. I'll now open the second public hearing, application AFD-02-26, renewal of the Cooks Mill AFD.
Thank you very much. And the first of our two renewal cases this evening, again, is a consideration As to whether or not the Planning Commission, what their recommendation will be surrounding the renewal of the Cooks Mill AFD to consider whether or not it should be renewed for an additional 10-year period until August 31st, 2036. So some context first. The Cooks Mill Agricultural and Forestry District currently consists of 46 parcels, totaling 5,459 acres, and is located in the central northeastern part of the county. The district core is roughly a mile and a half north of State Route of New Kent Highway, and its northern edge borders the Pamunkey River and King William County line. The Cooks Mill, again, AFD, is set to expire on August 31st, 2026, so next month. Now, as always the case with these renewal considerations, all members of the district were contacted by the Planning Division and were informed of the district's expiration date of August 31st, 2026 in December 2025. All parcels currently rolled in the district are zoned A1 agricultural as well, and the supporting response letters from all of the property owners with property in this district were included in your meeting packet, and all previously approved land uses continue to be reported annually to the Commissioner of Revenue. All letters received from current members indicated their desire to continue their membership in the district and request renewal of the district, with the exception of Alan Schultz, owner of tax map parcel 25-33, a 96.5 acre parcel, who indicated he wishes to let his enrollment in the AFD expire, as well as Jonathan C. Kinney, trustee, and Ralph W. Johnson, trustee, owners of tax map parcel 25-41, a 366 acre parcel, who indicated they wish to do the same, let their parcel's enrollment lapse. In addition, as Ms. Rose noted earlier in the evening, one property owner owning a total of one parcel, Ms. Sharon Lee, owner of tax map parcel 27-1-9, has not yet provided a response to staff regarding their desire to continue enrollment of the parcel in the Cooks Mill AFD. We are continuing diligent pursuit in our efforts to get in contact with Ms. Lee in order to confirm her desire to either re-enroll or let her enrollment lapse relative to the Cooks Mill AFD. But in conclusion, the district appears to comply with the state requirements of state and county codes regulating the AFD program and does promote land use patterns that are consistent with the current comprehensive plan. Therefore, staff recommends renewal of the Cooks Mill AFD district for a period of 10 years, and likewise at their June 25th, 2026 meeting, the AFD Advisory Committee unanimously voted to do the same and forward a favorable recommendation of approval to the Planning Commission and Board of Supervisors. That concludes this renewal presentation, but happy to answer any questions you might have on this.
Commissioners, any questions for Mr. Silva? Hearing none, can we check the sign-up sheet, please? Let the record show no one has signed up. I will now close the public hearing and turn it back over to the chairman for consideration.
Thank you, Ms. Rose. Any discussion among the commissioners? Please, let's announce it. If not, do I have a motion?
Mr. Chair?
Actually, I saw Reverend Hathaway first this time.
Thank you. Thank you, Mr. Chairman. In order to address, protect, and promote public convenience, necessity, general welfare, and good zoning practices in the county, I move to adopt Resolution PC 0926 to forward application AFD 02-26 to the New Kent County Board of Supervisors with a favorable recommendation.
Again, the recommendation is favorable for this application. Mr. Ryder, roll call, please.
Ms. Townsend,
Aye.
Ms. Johnson,
Aye.
Mr. Moyer,
Abstain.
Mr. Dombrowski,
Aye.
Ms. Thomas,
Aye.
Mr. LaRochelle,
Aye.
Mr. Davis,
Aye.
Ms. Rose,
Aye.
Reverend Hathaway,
Aye.
Mr. Bennett.
Aye. Ms. Rose, back to you.
Thank you, Mr. Chairman. I'll now open the third public hearing, application AFD-03-26, renewal of the Allen's Run AFD.
Thank you very much. And again, the final district renewal consideration for this evening is that of the Allen's Run AFD to consider whether or not it should be renewed for an additional 10-year period until August 31st, 2036. Some context, the Allen's Run AFD consists of 25 parcels, totaling 782 acres, and is located in the southeastern part of the county. The district core is bounded to the north by I-64, to the east and south by Route 106, to the west by Woodhaven Shores and New Kent Airport, and there are also 3 parcels located southeast of Route 106 and 3 lying just southwest of Route 60. All members of the district were contacted by the Planning Division and were informed of the district expiration date of August 31st, 2026. And all parcels currently enrolled in this district are likewise zoned A1 agricultural. Now, the supporting response letters are included in your meeting packet, and all previously approved land uses do also continue to be reported annually to the Commissioner of Revenue. All letters received from those members indicated their desire to continue their membership in the district and request renewal of it, with the exception of Judith Dean, owner of tax map 31-41, who indicated she wished to let her parcel's enrollment expire. And staff has not yet received a response from Chad R. Greedon and Christopher M. Long, owners of tax map parcel 31-1-L. Similarly, as is the case with Ms. Lee, we are continuing to try to get in contact with them. Thankfully, we have spoken to these owners before, and they have indicated they are intending to submit the letter requesting their continued enrollment. We have not yet received that, but thankfully we are in contact with these folks at least. However, the withdrawal of the parcel as requested by Mrs. Dean would not endanger the acreage of the core in such a way where the AFD would not be able to continue its enrollment. It is well above that 200-acre mark still. In any case, in conclusion, as the district appears to comply with the regulations surrounding state and county regulations surrounding AFDs and promotes land use patterns that are consistent with the current comprehensive plan, staff is again recommending renewal of the Allens Run District for a period of 10 years until August 31st, 2036. Again, at their June 25th meeting, the AFD Advisory Committee voted to do the same and forwarded a favorable recommendation of approval to the Planning Commission and Board of Supervisors. So that concludes my presentation here. Happy to answer any questions or concerns you may have.
Commissioners, any questions for Mr. Silva? Can we check the list, please? Let the record show there is no one signed up for the public hearing. So I will turn it back over to the chairman for consideration.
Thank you very much. Commissioners, any final discussion on this application? Hearing none, is there a motion?
Mr. Chair.
Yes, Mr. Davis.
In order to address, protect, and promote public convenience, necessity, general welfare, and good zoning practices in the county, I move to adopt Resolution PC 1026 to forward application AFD 0326 to the New Kent County Board of Supervisors with a favorable recommendation.
Motion is to approve. Mr. Ryder, roll call, please.
Ms. Townsend?
Aye.
Ms. Johnson?
Aye.
Mr. Moyer?
Abstain.
Mr. Dombrowski?
Aye.
Ms. Thomas?
Aye.
Mr. La Rochelle?
Aye.
Mr. Davis?
Aye.
Ms. Rose?
Aye.
Reverend Hathaway?
Aye.
Mr. Bennett?
Aye. Ms. Rose, next application.
Thank you, Mr. Chairman. I'll now open the fourth public hearing, application AFD-04-26, additions to Pamunkey River AFD.
Thank you very much. And so item number 4 is the first of 6 addition requests that we'll be considering this evening. It was a request made by the Charlotte E. Woodall Trust to add tax map parcels 11-1-D and 11-15, totaling together approximately 3.91 acres to the Pamunkey River AFD. A copy of the application and supporting documentation provided with it have been included in your meeting packet for this evening. Now, a little context. The Pamunkey River AFD currently consists of 56 parcels, totaling approximately 8,142 acres, and is currently set to expire on August 31st, 2034. One of our larger AFDs, if you're wondering. The Pamunkey River AFD is located generally in the northeastern portion of the county along the Pamunkey River and west of Talliesville Road, as well as east of Old River Road. It is bordered by King William immediately to the north. The subject parcels in this specific request are located just off of Old Church Road, approximately 1/3 mile north of the intersection of Old Church and Talliesville. Now, the subject parcels at the center of this current edition request, again, together total 3.91 acres. So that's 0.91 acres from 11-1-D and 3 acres from 11-15, with 11-1-D's acreage devoted to timber and 11-15 devoted to agriculture. This is a perfect example of what I had mentioned during our refresher earlier this evening, where typically neither Either of these parcels independently or even combined in this case would have the requisite acreage necessary to qualify for the use value taxation benefits of being enrolled in the AFD. However, in this case, they are located contiguous to an existing 54.6 acre tract that does currently have forestry and agricultural activities on it and is titled in the exact same name as the owner in this request. So that's a kind of point of note, unique element to this application compared to those you'll see the rest of the night. In any case, they're both owned A1 agricultural and are designated by the county's comprehensive plan as having a rural lands future land use designation, which the comprehensive plan does define as being aiming to maintain the rural character of the county, allowing agricultural, forestry, and agritourism. Development density is kept very low. As evidenced by the materials provided by the applicant with their submission and confirmed via an inspection conducted by staff from the Virginia Cooperative Extension, the applicant leases the land to Patrick Evelyn, who actively maintains and uses 11-15 to cultivate the growth of hay, which is then sold off. In addition, 11-1-D is, as I mentioned, part of the larger timber tract, together with the 54.6 acre tract located immediately next to these subject properties. You can kind of see it outlined here in yellow, along with tax map parcels 11-14 and 11-1-E, again, which are both owned by the applicant and already enrolled in the Pamunkey River AFD. The timber stand itself is comprised of a mix of mixed pine and hardwood tree species, which the forestry report provided by the Virginia Department of Forestry indicated are in moderate to good forest health. The applicant is currently working to establish a pre-harvest plan for future timbering of the tracts. A little bit of soil information for the soil fanatics amongst you for the respective subject parcels. In conclusion, staff is also recommending approval of the request to add these parcels to the Pamunkey River AFD, as the request appears to comply with the pertinent state and county requirements surrounding AFDs, promotes land use patterns that are consistent with the comprehensive plan, and generally finds that adding the subject properties into the AFD program would conserve and protect commercially viable agricultural and forestry land in the county. In addition, at their June 25th, 2026 meeting, the AFD Advisory Committee voted unanimously to forward a favorable recommendation of the addition request to the Planning Commission and Board of Supervisors. That concludes my presentation of this addition request, but happy to answer any questions.
Thank you, Mr. Silva. Any questions for staff? Let the record show there's no one signed up to speak. I will close the public hearing and turn it back over to the chair.
Thank you, Ms. Rose. Commissioners, is there a motion?
Mr. Chairman?
Yes, sir. Yes, Mr. Dombrowski.
I'd like to make a motion in order to address, protect, and promote public convenience, necessity, general welfare, and good zoning practices in the county. I move to adopt Resolution PC 11-26 to forward application AFD-04-26 to the New Kent County Board of Supervisors with a favorable recommendation.
Thank you, sir. The recommendation is to forward with an favorable recommendation. What say you, the commissioners? Will you poll them, please, Mr. Ryder?
Ms. Townsend?
Aye.
Ms. Johnson?
Aye.
Mr. Moyer?
Abstain.
Mr. Dombrowski?
Aye.
Ms. Thomas?
Aye.
Mr. La Rochelle?
Aye.
Mr. Davis?
Aye.
Ms. Rose?
Aye.
Reverend Hathaway?
Aye.
Mr. Bennett?
Aye. Ms. Rose, please continue.
Thank you, Mr. Chairman. I'll now open the hearing for application AFD-05-26, addition to Upper Chickahominy AFD.
The fifth item documented for your consideration this evening is another addition request, this time made by Jeffrey R. and Connie S. Sampson, who have applied to add tax map parcel 8-50, totaling approximately 52.65 acres to the Upper Chickahominy AFD. Now, the Upper Chickahominy AFD currently consists of 18 parcels. As mentioned earlier this evening, actually, this is the same district from which the renewal request, or withdrawal request, rather, was pertinent. But just to recap, 18 parcels totaling approximately 1,417 acres, not set to expire until August 2028. I'll spare you the kind of description of where it's located since we already did that once tonight, but the subject parcel in this specific request is located just north of Longhorn Drive, approximately 900 feet east of the Hanover County line, as can be seen here in yellow on this graphic. The subject parcel at the center of this request, tax map 8-50, contains a total of 52.65 acres, 8.3 of which are devoted to agriculture, and 43.52 are devoted to silvicultural activities. The parcel is zoned A1 agricultural and is designated by the county's comprehensive plan as having a rural lands feature land use designation. Again, the plan describes that as aiming to maintain rural character, allowing agricultural, forestry, and agritourism, with development density kept very low. Now, as evidenced by the applicant confirmed via an inspection from staff with the Virginia Cooperative Extension, the parcel is in active agricultural use as soybean fields. The Sampsons leased the field to Waitman Farms of Mechanicsville for its production. Regarding the timber component of the request, the parcel is part of a larger 154-acre timber tract, along with adjacent parcels, tax map 80-46 and 80-47, again, both of which are owned by the applicant and already enrolled in the Upper Chickahominy AFD. The larger tract itself is made up of 3 stands, stands A, B, and C accordingly, and is primarily comprised of mixed pine and hardwood tree species. Now, the forest stewardship plan provided with the application recommends invasive species control for stands A and C in the reevaluation of a harvest in 5 years, while indicating that stand B is ready for total harvest as is now. The applicants are currently evaluating options for doing so with a qualified forester. Again, a little bit of soil information for the subject parcel there for those that may be interested. But in conclusion, staff is recommending approval of the request to add the parcel to the Upper Chickahominy AFD, as it complies with pertinent state and county regulations, is consistent with the comprehensive plan, and would conserve and protect commercially viable agricultural and forestry land in the county. Likewise, at their June 25th meeting, the AFD Advisory Committee voted to do the same and forwarded a favorable recommendation of approval to the Planning Commission and Board. Happy to answer any questions there may be on this one.
Thank you, Mr. Silva. Any questions? The list, please. Let the record show there's no one signed up. I will close the public hearing and turn it back over to the chairman for consideration.
Thank you, Ms. Rose. Any comment or discussion regarding this application from the commission? Seeing none, do I hear a motion?
Mr. Chairman?
Yes.
In order to address, protect, and promote public convenience, necessity, general welfare, and good zoning practices in the county, I move to adopt Resolution PC-12-26 to forward application AFD-05-26 to the New Kent County Board of Supervisors with a favorable recommendation.
And the motion's for a favorable recommendation on this application. What's the commissioners, Mr. Rice?
Ms. Townsend?
Aye.
Ms. Johnson?
Aye.
Mr. Moyer?
Abstain?
Mr. Dombrowski?
Aye.
Ms. Thomas?
Aye.
Mr. La Rochelle?
Aye.
Mr. Davis?
Aye.
Ms. Rose?
Aye.
Reverend Hathaway?
Aye.
Mr. Bennett?
Aye. Thank you, commissioners. The motion passes. Return it to Ms. Rose, please.
Thank you, Mr. Chairman. I'll now open the 6th public hearing, application AFD-06-26, addition to Lower Chickahominy AFD.
Thank you very much. And this addition request was made by Everett H. and Janet G. Parsley, who have applied to add tax map parcel 43-67, totaling approximately 22.43 acres to the Lower Chickahominy AFD. Now, the Lower Chickahominy AFD currently consists of 11 parcels, totaling approximately 830.32 acres, and is not set to expire until August 31st, 2028. The Lower Chickahominy AFD is located in the far south-central portion of the county, along either side of Route 60 and Providence Forge. The subject parcel in this request is located at the intersection of Weber's Lane and Route 60, as can be seen here. Now, the subject parcel at the center of this current addition request contains, as I mentioned, a total of 22.43 acres, 7 of which are devoted to marsh and wetland, and 15 of which are devoted to agricultural activities. The parcel is zoned A1 agricultural and is designated by the county's comprehensive plan as having a conservation future land use designation. To tell you a little bit about that, the plan defines the conservation designation as focusing on preserving natural landscapes, prohibiting development, and including uses like conservation and passive public parks. As evidenced by the applicant and confirmed via an inspection conducted by staff from the Virginia Cooperative Extension, the parcel is an active agricultural use via the cultivation of cornfields. The applicant leases the land to NS Farms, Mr. Aaron and James Black of Charles City County, to be produced. And in conclusion, staff is recommending approval of the request to add the parcel to the Lower Chickahominy AFD, as it complies with all pertinent state and county requirements, promotes land use patterns that are consistent with the comprehensive plan, and would conserve and protect commercially viable agricultural and forestry lands here in the county. Likewise, the AFD Advisory Committee voted to forward a favorable recommendation of approval to the Planning Commission and Board of Supervisors at their June 25th meeting. Happy to answer any questions here.
Thank you, Mr. Sloan. Yes.
So let's step back to, is it A1 or is it conservation?
It is A1 zoning designation and has a conservation future land use designation.
Usually when it's listed as conservation, it's already getting some kind of tax break, right?
So again, that's the future land use designation, not the actual zoning of the parcel. The actual zoning is still
It's
A1
still
agricultural,
A1?
correct, yeah. Mm-hmm.
I will say I didn't see it.
If you saw that there were no, let the record show. I'll close the public hearing and turn it back over to the chairman for consideration.
Mr. Silva's getting his steps in tonight. Final discussion among the commissioners on this. Hearing none, is there a motion, please?
Mr. Chair?
Oh, okay. Ms. Johnson, please. He's
In order
talking
to
up.
address, protect, and promote public convenience, necessity, general welfare, and good zoning practices in the county, I move to adopt resolution PC-13-26 to forward application AFD-06-26 to the New Kent County Board of Supervisors with a favorable recommendation.
The motion is to send a favorable recommendation to the board. What say you, commissioners? Mr. Ryder?
Ms. Townsend,
Aye.
Ms. Johnson,
Aye.
Mr. Moyer,
Abstain.
Mr. Dombrowski,
Aye.
Ms. Thomas,
Aye.
Mr. La Rochelle,
Aye.
Mr. Davis,
Aye.
Miss Rose,
Aye.
Reverend Hathaway,
Aye.
Mr. Bennett.
Aye. Returning it to you, Ms. Rose.
Thank you. I'll now open the public hearing for application AFD-07-26, addition to Pamunkey River AFD.
Alrighty, so the seventh item docketed for consideration is another addition request, this time made by Premier One Investments 757 LLC, who have applied to add tax map parcel 10-38, totaling approximately 24.5 acres to the Pamunkey River AFD. I have earlier this evening already kind of described in general the location of that AFD, so I'll spare you that. But the subject parcel in this specific request is located at the intersection of Old Church Road and Tunstall Station Road. It's a little bit hard to see because this is such a large AFD again, but you can kind of see it right there in yellow, zoomed in view right here. Now, the subject parcel at the center of this current edition request, tax map 10-38, contains a total of 24.5 acres, 8 of which are reportedly devoted to pasture, 2 of which are marsh and wetlands, and 1 is reportedly used for agricultural purposes, as well as 1 being occupied by an existing home site present at the parcel. The parcel is zoned A1 agricultural and is designated by the county's comprehensive plan as having a rural and future land use designation. Again, that's defined as aiming to maintain the rural character of the county, allowing agriculture, forestry, and agritourism, and development density is kept very low. So a little bit of background for this one. A Virginia Cooperative Extension agent did go out on February 17th of this past year to conduct an inspection and did not observe active agricultural use of the property taking place at the time of that inspection. As reported by the applicant, the parcel is currently being set up for the cultivation of livestock, including goats, chicken, and horses, and the cultivation of crops. With their application, the applicant did provide proof of purchase of equipment, including a compact tractor, a finishing mower, vegetable and fruit seeds, and prior to, well, actually, back one more step. There was originally an AFD Advisory Committee meeting scheduled for May. Unfortunately, we were not able to make a quorum at that meeting, so none of these items were able to be considered. But at that meeting, some questions were posed by members of the committee who expressed maybe some concerns about the degree to which the property may be actively used for agriculture or the extent to which it was being set up for those purposes. And asked staff to contact the applicant to request additional documentation, verifying that things were headed in this direction. So the applicant did just that, and in response to staff's request for additional documentation to verify agricultural activities at the site, the applicant reached back out to staff on June 22nd to provide indication of additional costs incurred, as well as of a narrative justification for why they believe their parcel should be included in the district. That was provided with your meeting packet, so that should have been available to you all. The applicant, Mr. Spratley, was in attendance earlier this evening. I think he may have jumped out. So unfortunately, we won't have an applicant here to speak to the commission on any questions they may have. But ultimately, despite these concerns expressed by the AFD Advisory Committee at their June 25th meeting, they did vote to forward a favorable recommendation of approval for the request to add the parcel to the Pamunkey River AFD. One thing I will note about that is, again, I provided for each of you a copy this evening, the section from our local code, criteria for evaluating an application. As I mentioned earlier, that is also verbatim taken from the state code. I have that here up on the screen right now. This is something that became kind of a topic of discussion amongst the members of the AFD Advisory Committee. Again, these are the criteria that both the state and local code establish as being able to be considered when evaluating an application for an addition. So there was some discussion about the degree to which this request would check a number of these boxes. Ultimately, the members of the AFD Advisory Committee found it did for them, which is kind of why their vote went that way. So I did want to highlight that specific point, but I digress. That's the end point for this presentation, but happy to answer any questions I can for you all.
Thank you, Mr. Silva. Any questions? Yes, Ms. Thompson.
So how far is the property been developed? Is it ready for cattle, or have they not pushed off at all?
That was not indicated to be the case at last month's meeting. There's still, I don't want to speak. That's kind of the benefit to having the applicant here, so I don't want to speak on his behalf too much. As far as any inspection or information relayed by the applicant, it is not yet set up for cattle. So I can confirm that. The extent to which what his ongoing efforts are to do that. He's incurred costs to, materials to build future pen areas, that sort of thing. But as far as I'm aware, nothing has been established at the site yet.
So in most cases that we look at these sites, though, the sites have to have a purpose, and the purpose needs to be active. So as far as right the moment, he's not active with what he's doing.
It's a great point, and I think that in a way kind of brings to mind what we were talking about during the refresher with respect to, in order to qualify for the tax benefits of this program, which is one of the most appealing things, they do need to certify that they are meeting the requirements to be granted those benefits with the Commissioner of Revenue. If he's not able to do that based on non-active production, then he won't receive those benefits, regardless of what may have been posed as part of the application or outlined as what the future plan is. Again, there are other benefits to being enrolled in the AFD, so whether or not he's able to receive the tax benefits, that's up to the commissioner to determine whether or not the activities he's proposed are actually being established or get up and running by the time that they are to make that determination. But again, these are the other criteria that can be considered in addition to that. Under number 8 here, the present status of agriculture and forestry is just one of many things that can be considered as far as criteria for evaluating an application. I certainly don't mean to urge the commission to view the request in one light or another, but just am drawing to your all's attention there are other factors that can be considered as part of the request and kind of outlining the thinking that ultimately kind of was the direction the AFD Advisory Committee went.
Mr. Silva, is there an indication how long they've owned the property? Did they recently acquire?
They did recently purchase it, and that was part of, again, I don't want to kind of speak for him. I can say at the AFD Advisory Committee meeting, he made comments to the effect of they had recently bought the property, and I believe it was October of 2025. So not an extraordinarily long time, and he said there was a number of kind of more broad site maintenance issues or property maintenance issues they needed to address before they got to work on this, which is why he kind of asked the members of the AFD Advisory Committee to be patient with him while he worked to do that, given that the property has not been in his ownership for that long. Certainly, like I said, at the AFD Advisory Committee, there was some concern, for lack of a better turn of phrase, that maybe the cart was being put before the horse, but they ultimately did vote to forward a favorable recommendation.
Madam Chair. Ms. Silva, so the effective date of the proverbial tax break, it was at a January 1st of 2027 effective date, or is it it's not prorated? I don't think New Kent prorates anything, right?
No.
So when would, so the benefit if this applicant does get his agricultural operation going, and again, the Commissioner of Revenue is confident that it is an agricultural use, that benefit, in my opinion, it wouldn't occur until January 1st anyway, right?
Correct.
It's not immediate.
Correct.
Benefit.
That's my understanding.
I do maybe recognize or understand sometimes if it's, especially if property is new to the applicant, that this is a desire they want to do, and I know the windows, I guess, to get a part of the program don't occur except during a certain window each year.
Correct.
So, I don't know if I fault an applicant for wanting to prep for this to get the benefit, but at the same time, they may take some, he may have some plans to get it ready before, because it is newly acquired.
Yep.
I think that maybe is a fair point.
And that, my question ties in with that. So the application is due March 1st, right, to add to the NAFD? Yeah, it's not a rolling admissions. It's March 1st of every year. It's a one-time thing. It's a one-time thing where you got to get it in by March 1st. So I'm wondering if that's what this guy's doing. Ready, but
I think that's
get it in by March 1st this year. He's got to wait till March 1st.
Right, right. Yeah, that's a great point. I think the March 1st thing is a little bit more of a local standard of practice than like a hard requirement of the program. There is other verbiage that requires the AFD Advisory Committee to hear within X days of them being received. So if we do receive something, a number of months down the line, we would not ask them to wait until the following year per se. And a lot of that is time to kind of take place early in the year as we approach prime growing season as well, to get any parcels that want to get that benefit in prior to that time frame. But I digress. Hopefully that answered your question.
Yes, Ms.
I will comment, the due date of March 1st was so that the AFD could get their information done, because then the Commissioner of Revenue comes in and reviews the taxes on the AFDs, and hers are due in May. So that's basically, if it's actively being looked at in March and it goes past it's usually acceptable, but it's not going to linger for months. But it needs to be done so that the Commissioner of Revenue can start to do her paperwork.
Point. And it, on that same line of thinking, these are unusual requests that they have to go through 3 months of hearings. So we kind of do want to build in enough of a timeline in anticipation, because all of these districts are at this point set to expire on August 31st of what X year of whenever they expire. So by asking applications to be submitted in March, that gives us enough time to prepare all of the staff analysis and reports, et cetera, prior to them going conceivably to the AFD Advisory Committee in May, Planning Commission in June, Board in July, building in an extra month in case something like what was the case this year, not able to make a quorum for the AFD meeting in May. We leave some buffer room for that to make sure everything still gets to the board by that August date.
Reverend Hathaway, did you have a question?
I think it's been answered, but
let me just ask this. Is there any benefit in, if we want to approve this, make it condition upon him meeting that requirement by the end of the year?
It's a great question. I would say, in my mind, it would be a little bit redundant in that he still would, in order to receive any tax benefit, would need to certify that he meets all of those appropriate requirements with the Commissioner of Revenue. So regardless or not of whether the commission were to add a condition like that, he wouldn't receive the tax benefit unless he's able to prove that he complies with the regulations necessary to get it. Otherwise, he would just, by being an AFD, receive the other benefits that I mentioned at the beginning of the hearing: protection from overly restrictive zoning regulations, protection from certain types of eminent domain, that sort of thing. Also, just restricting more intense development of the site. So it's a long-winded way of me saying I think there are already safeguards in place to make sure that even if he were to be added to the district, he wouldn't receive the tax benefit unless he's able to certify that to the Commissioner of Revenue that he meets the regulations.
I think I'm comfortable with that, but I would hate to see a lot of applications come in like this. Yeah.
Agreed.
Madam Chair? Just an observation, too, of being on a farm, raised on a farm. If an applicant, for example, they want to raise corn, they're not prepping their land today for corn in the spring. So, there's some applications or some farming operations that they wouldn't necessarily be doing something actively today for something they may wait 6 months or 8 months for to do. So, and again, I guess certainly we have to believe the applicant to a great degree when they apply, unless there's something obvious to us that they're not being totally honest and with their application. But again, from the aspect of Commissioner of Revenue is going to prove the point per se, and again, if that's one of their main reasons for doing this, then again, it's not what we do; it's what the Commissioner does or finds.
To flip it onto the other side, to be consistent with the AFDs, we've always stuck with the procedure that it is productively being actively farmed. And I feel at this point it's a little premature. I would say that you need to get the actively being farmed in place. Commissioner of Revenue is going to end up having to do the same exact thing as what you do. They're going to have to go back out and look. But I don't feel that we're doing our homework, because if it's not actively and we vote on it, then it's not consistent with what we vote for.
Madam Chair.
I have a quote.
Oh,
Go ahead.
go ahead.
Okay. Tell me, when the AFD group vote on this and they have approved it, I guess I'm struggling with, if they have safeguards in place. He presented the evidence, you gave them the evidence, they approved it. Now we are going right back over what they've already approved. I know it's coming before us because we have to do it, but I just feel like at this point, if the AFD group that is particularly looking at, all they do is look at AFDs. I'm having trouble with this because they've already approved it, and we're sitting going back and forth now, but they've already approved it. They looked at what he presented. They've given all of the information. He's given all of the information. Can we say, are we taking this amount of time on this applicant? I guess I'm feeling why. Because there are people that come before us that we don't take this amount of time for, but we know that the application is more than what they're saying it is. So I'm going right back to the point of, are we having different treatment for different applicants? Again, I'm seeing it in front of my face. And so that I'm speaking it on record now.
Okay. Understood.
Madam Chair, I'm going to agree with Ms. Townsend for a bit, and let me explain why I agree with Ms. Townsend for a bit. Number one, when I look at the application, I look at what is it primarily being used for in a land use value. On this particular case, everything that I saw was a residential property with a sub-activity of agricultural, more of a hobbyist farm or residential garden than anything else. I wish the applicant was here so he could explain his differences, in my opinion, and maybe that would sway me. So, but to me, this property is being used as a residence, not as an agricultural forestal district. And the percentages of land use that were outlined in the information provided by the staff kind of proves my point. I mean, it says, this is a 25-acre parcel, 8 acres to agriculture, to pasture, 2 to wetlands, marshes, 1 acre cropland, which is a low percentage of that total acreage. Number 2 is the applicant provided evidence that he was entertaining agricultural use. All those purchases that I remember seeing were accomplished since December of 2025, including the mower, the seeds, and everything. The fencing, which was primarily used to outline the gardening activities that were there. The mowers is simply because he has 8 acres to mow, and it's a finished mower. It's not tilling crops or it's not a haymaker or anything like that, or a roller, baler. It's mowing grass. So I agree with Ms. Townsend that he is preparing possibly for agricultural use, but he's not there yet. It's like saying, I painted the car and you only have it in primer. It's not painted yet. So I rest my case on that. He's preparing. Thank you.
Any other questions, comments?
Just maybe a little bit of follow-up. I've been looking at his receipt. He does have a finished mower, but he's buying a tractor. Well, it says $31,000 for the tractor and $4,000 for the mower. So, you can buy implements, obviously. When I buy my tractors, I buy multiple implements, including a mower. I will say, as far as being a residential, probably almost the majority of A1 parcels that have any farmer next to it, there's a house on it as well, including my own. I have a house and on mine. So it's A1 is the zoning. Again, part of and I don't get credit for my entire parcel. I own 18 acres. 10 of it is in AFD, or 10 of it is shown to be agricultural for under production. But
I'll say you're under production.
I'm under production, but it could have been fallow, and then I decided I want to put it back in production too. So but it doesn't happen, right away. Again, we're necessarily not there to prove that they do it, because we've had other applicants that we don't know if they've ever, we don't get a report, I think, from Commissioner of Revenue saying that all the other applications we've approved that there's actual agricultural activities going on. I don't know. Maybe I'm just more inclined to take the applicant at his word or based on his application. But what was, and out of curiosity, what was the AFD board's vote?
They voted unanimously to recommend a favorable recommendation of approval.
Thank you.
Mr. Silva, was there discussion similar to the discussion of this board?
Very similar.
Okay, thank you.
Any other comments? All right, and the list, let the record show no one signed up to speak. So I will turn it back over to the chairman for further consideration.
Thank you, Ms. Rose. I think we've had enough discussion, unless we want to continue it. If there's no more discussion, I will hear a motion, and I believe Reverend Hathaway.
Well, I do.
Yeah, discussion.
Discussion. My concern initially was that the applicant is making a promise but not actually doing it. And so that caused me quite a bit of concern and would probably have caused me to say no. But then when I heard what Mr. Davis said, who's actually farming, now I'm kind of, maybe, yeah.
Just as a comment too, I think most of the applications we see outside AFD are all based on promises. Because it's nothing, it's the desire to do something is why we have the applications we get, whether it's for rezoning or CUP. I mean, it's not something that's happened and that we're considering. So this is maybe the difference compared to other applications we get where we want to see something having already occurred and we're going to grant an application versus other applications we get is that it's anticipated that they want to do something and we're approving it to do something. So I'm not sure if I want to have a difference in considerations in a way.
Mr. Chairman, I think though, to be consistent with most of the AFDs coming here, it's what the land does. It's not what you purchased. It's what have you produced. And I think that's the whole big question here, is what is the purpose of this property and what is it showing?
Can I jump in here?
Sure.
Okay, so I want to, one of the questions that you had there, I want to answer it from my perspective, not to say that I'm right, but when I first purchased property, I did not have the animals that I have now. But what I can say is I was doing things that people couldn't see. It may be things that he's doing that we can't see, like infrastructure, underground water, things of that nature. You can't see it, but you're building your farm up, doing things that would be that was good for livestock. So I was actively taking care of infrastructure on my property. But that's what I'm saying. We can't always say, well, I think there's a fine line there of how much are we going to dwell down into what we can see versus what we can't see. Because there could be things actively happening that we can't see. And that's just my take on it.
Chairman, I would like to get clarification from the attorney on this.
Yes, sir.
Given the fact that the applicant is not currently meeting the requirement, but has purchased equipment, is that sufficient for us to say yes in terms of what what we're required to do in considering this case as if we would consider any other case? The applicant is not currently meeting it, but has purchased equipment. Is that sufficient?
Sure. 1 second. Do you have control of the slides? Can you pull it back to the list of factors? I'll get to your question. Mr. Chair, Vice Chair, and members of the Commission, I just put this back right up here because a couple things to respond to you, Commissioner and Reverend Hathaway. One, each case is decided on its own merits. So any other actions that this board has taken before does not set precedential value for how future or current applications should be voted on. So each one's decided on its own merits. Two, it is correct, and there were some conversations on the AFD advisory board that talked and discussed about how active farm use was always a factor that was being considered, but the board was, they had a good discussion about this criteria that's under our local code and also in our state code. And the way that you have, as commissioners, have to view this is the totality of the circumstances. So my direct response to you, Commissioner, is not as a standalone, but in terms of a whole confluence of the situation, the circumstances, the application that's before you, the evidence that's presented before you. And with that criteria, I think this discussion has been fruitful in that regard. So whatever decision y'all make, you know, I think it has good legal standing. I'll put it that way, Reverend. So it's a totality of circumstances of all of that. And I think, if I may, Mr. Silva, I think some of the AFD members looked into the comprehensive plan, right, number 5, future land use, into it. I think they were generally encouraging about prospective agricultural use, and they were excited that the new property owner wanted to endeavor on it, despite the fact that it was a bit of the cart before the horse. That's verbatim from what some of the AFD advisory members said. But they took a discussion based on the totality of all the criteria established there and rendered a decision unanimously to forward a recommendation before this body. I hope that answers your question.
Any final statements, Mr. Silva? Any final statement? No?
Not from me.
Final discussion? If not, do I hear a motion?
Mr.
Mr.
Chairman.
Davis. Oh, I'm sorry.
Go ahead, Mr.
Yes, Mr. Marshall.
In order to address, protect, and promote public convenience, necessity, general welfare, and good zoning practices in the county, I move to adopt Resolution PC-14-26 to forward application AFD-07-26 to the New Kent County Board of Supervisors with a favorable recommendation.
The motion is to pass on the application with a favorable recommendation. How say you, the commissioners? Roll call, please.
Ms. Townsend,
I'd like to say no based upon the count. I think it's premature.
Ms. Johnson,
Aye.
Mr. Moyer,
Abstain.
Mr. Dombrowski,
Aye.
Ms. Thomas,
Aye.
Mr. La Rochelle,
Aye.
Mr. Davis,
Aye.
Ms. Rose,
Aye.
Reverend Hathaway,
Aye.
Mr. Bennett.
No. Motion passes. Thank you very much, commissioners. Ms. Rose?
All right. Coming down to the final stretch. I'll now open the public hearing for application AFD-08-26, addition to Higgins Swamp AFD.
Alrighty, and so this addition request made by Leon B. and Geraldine F. Bowery Trust is one in where they have applied to add tax map parcel 19-48, totaling approximately 114.75 acres to the Higgins Swamp AFD. Now, for some context, the Higgins Swamp AFD currently consists of 10 parcels totaling approximately 682.92 acres and is currently set to expire on August 31st, 2025. So as you may recall, this is one of the ones that we had reviewed for renewal last year. Since it's been a while, the Higgins Swamp District is located in the western portion of the county, approximately 1 mile east of the county border shared with Henrico. The district's core is located roughly 1/5 mile north of New Kent Highway, with a small portion also located immediately southeast of the intersection of New Kent Highway and Henpeck Road. The subject parcel in this specific request is located off of Henpeck Road, bounded to the north by Quinton Park subdivision, and to the south by I-64. Now, the subject parcel at the center of this current request contains, again, a total of 114.75 acres, all of which are reportedly used for forestry. The parcel is zoned A1 agricultural and is designated by the county's comprehensive plan as having both a residential development as well as a village future land use designation. Now, the comprehensive plan defines the residential development future land use designation as encompassing areas intended for various residential types, from single-family homes to multifamily units, with densities ranging from low to moderate, and the village designation as dense, compact areas of mixed use, including higher density residential and commercial uses, creating a strong sense of community and identity. The forest management plan provided with this application establishes 4 strands for the subject property in the request. Stand A is primarily loblolly pine, while Stand B, Stand D1, and Stand D2 are all mixed pine and hardwoods. Stands A, D1, and D2 were most recently harvested in 2014 as evidenced by timber sales receipts provided with the application and were replanted in 2016. The Forest Land Use Management Plan provided by the Department of Forestry with the application does recommend thinning within the next 5 years to ensure stand health, and that the applicant has stated that they intend to prioritize the long-term health of the stands through active management activities, including pest and invasive species management, as well as the Department of Forestry recommended thinning. So it is worth noting, as alluded to in the timber sales receipts from 2014 and replanting in 2016, this is a tract that has historic use as a silvicultural parcel, despite its future land use designations. In conclusion, staff is recommending approval of the request to add tax map parcel 19-48 as the request appears to apply with the requirements of state and county code, and finds that adding the subject property into the AFD program would conserve and protect commercially viable forestal lands here in the county. Likewise, at their June 25th meeting, the Agricultural and Forestal District Committee voted to forward a favorable recommendation of approval to the Planning Commission and Board of Supervisors. Happy to answer any questions here.
Any questions? Hearing none, and there's, let the record show there's no one signed up for this hearing. I'll close and turn it back over to the chairman.
Thank you, Ms. Rose. My dear commissioners, any discussion on this, please? Hearing none, do I have a motion?
Mr. Chair?
Yes, sir. Mr. Davis.
In order to address, protect, and promote public convenience, necessity, general welfare, and good zoning practices in the county, I move to adopt Resolution PC 1526 to forward application AFD 0826 to the New Kent County Board of Supervisors with a favorable recommendation.
Motion is for a favorable recommendation for PC 15-26. What say you, commissioners? Mr. Ryder.
Ms. Townsend?
Aye.
Ms. Johnson?
Aye.
Mr. Moyer?
Abstain.
Mr. Dombrowski?
Aye.
Ms. Thomas?
Aye.
Mr. LaRochelle?
Aye.
Mr. Davis?
Aye.
Ms. Rose?
Aye.
Reverend Hathaway?
Aye.
Mr. Bennett?
Aye. Return it to you, Ms. Rose.
Thank you, Mr. Bennett. For the last public hearing of the evening, I'll now open the hearing for application AFD-09-26, additions to Cook's Mill AFD.
We've made it, folks. The ninth and final item docketed for consideration this evening is another addition request made by Richard S. and Crystal L. Lloyd, who have applied to add tax map parcels 26-5-1, totaling approximately 25.04 acres, and 26-5-2, totaling approximately 25.01 acres, together totaling approximately 50.05 acres to the Cook's Mill AFD. Now, we already talked a little bit earlier tonight about the Cook's Mill AFD, so I'll spare you the description of where that's located, but the subject parcels in this specific request are located off of Cook's Mill Road at the end of Mill Isle Way. And as mentioned earlier this evening, the Cook's Mill AFD is concurrently being considered for renewal with an additional 10 years on it until August 2036. So the first parcel in the request, 26-5-1, again contains 25.05 acres, 12.65 of which are marsh and wetland, 11.39 of which are devoted to timber. For the second parcel, 26-5-2, again it contains 25.01 acres, 10.05 of which are marsh and wetlands, and 13.96 of which are devoted to timber. Both parcels are zoned A1 agricultural and are designated by the county's comprehensive plan as having that rural lands designation, future land use designation we've talked so much about this evening. Again, that's defined as aiming to maintain rural character, allowing agriculture, forestry, and agritourism, with development density kept very low. Now, the Forest Land Use Management Plan provided with the application establishes two stands for the subject properties involved in the request. Stand A is made up of young mixed hardwood with scattered pine, and Stand B is mixed hardwood with scattered pine. Per indication of said plan, the applicant intends to manage the property for forest health and continued growth in the near term and establish a pre-harvest plan in a number of years. In terms of future harvest, the plan recommends timber harvest in Stand B first and forest weeding in Stand A to encourage hardwood regeneration in that specific stand of the tract. In conclusion, staff is recommending approval of the request to add these parcels to the Cook's Mill AFD as the request appears to comply with pertinent state and county codes, promotes land use patterns that are consistent with the comprehensive plan, and generally finds that adding these subject properties into the AFD program would conserve and protect viable silvicultural land in the county. Happy to answer any questions here.
Any questions for Mr. Silva? Any discussion? Hearing none. Let the record show there's no one signed up for this public hearing, so I will close and turn it over to the chairman for consideration.
Thank you, Ms. Rose. To our commissioners, any discussion on this application? Nobody volunteering anything. Do I have a motion? Yes, Ms. Johnson.
In order to address, protect, and promote public convenience, necessity, general welfare, and good zoning practices in the county, I move to adopt resolution PC-16-26 to forward application AFD-09-26 to the New Kent County Board of Supervisors with a favorable recommendation.
Thank you, Ms. Johnson. Mr. Ryder, roll call, please.
Ms. Townsend,
Aye.
Ms. Johnson,
Aye.
Mr. Moyer,
Abstain.
Mr. Dombrowski,
Aye.
Ms. Thomas,
Aye.
Mr. La Rochelle,
Aye.
Mr. Davis,
Aye.
Ms. Rose,
Aye.
Reverend Hathaway,
Aye.
Mr. Bennett.
Aye. Thank you very much, commissioners. The motion passes. Does anybody need a short break? We've been at it for a couple hours. If not, I'm going to continue on. All right. Seeing such. Item to number 10, Chairman's report. Just one item. I think you may have noticed that we have a couple more items on our agenda. One was Mr. Zhang making a presentation on public hearing consideration guidelines. And you'll see later that Mr. Moyle will be making a Board of Supervisors report, trying to refresh us what's happened in the last month. I think you'll see a couple more items added to our agenda just to keep us all fully informed. So just be on the lookout as we adopt more items for the standardized agenda. For the future meetings. Thank you. Not tonight. You're welcome. Reverend Hathaway, do you have a planned RVA?
I do.
Thank you.
Yes, several things I want to share. We were able to get Kristen Ho, who is part of Plan RVA staff. She works with public outreach. She is now participating in our Community Resource Committee, and I'm excited about that because that's a vital connection that we needed. There are a lot of services that come through Plan RVA, and we now have a direct connection. One of the programs that is available is a Weaver grant. Plan RVA has been approved to participate in that program. The grants are either in the amount of $2,500 or $5,000. Now, it's the basic guidelines say that any community project that is measurable, and you'll have to submit what you've achieved based on the grant that you apply for. I do know that several have been applied for through New Kent, and I'm excited about that. The Richmond Regional Resident Speak Up Survey is now available. Please, please, please go to Plan RVA's site and click on that. It takes about 8 minutes to do, but that gives us an opportunity to get input from New Kent on what we want for our region. That's all.
Thank you very much,
Sure.
Reverend Hathaway. Item number 12 is Board of Supervisors report. Mr. Moyer, do you recap for us, please?
I'll combine Commissioner's report and Board Supervisors and go on with
Okay.
Reverend Hathaway's comments. Ms. Hott's going to be at my sidewalk meeting tomorrow at 9 o'clock, and then she's also going to be at Jolene's Winery on Friday night to show that type of commitment to getting the input in from New Kent. And she's real excited about Reverend Hathaway and everybody else's commitment to get the region in general. Also, speaking of surveys, there is a Richmond Regional Tourism Survey out there too that I know I've been sharing on Facebook. It's good to get the input from this area. One of our, if you count agritourism and sports tourism as real tourism, we're a vital part of the area for those things, and it's good to get everybody's input about that too. The Board of Supervisors meeting, the number of things that we took action on. One, purchase of a fire apparatus for $1.3 million. that will probably be in a station in about 3 years. Oops. Sorry. Because that's how long it takes for the backlog for that. But we had to make a decision on it, and we were able to use the camera speed money. $1.6 million for the sheriff's department to purchase equipment and the vehicles that they've been asking for a long time, and that is also coming from the camera and speed money. We also designated from the Rosie's fund $130,000 to get the ball rolling on the YMCA, looking at the facility, what we would have involved in that, and looking at that, and that's going to be in connection with Richmond's regional YMCA division. Also, we took action on the 1% sales tax. That will be a sales tax that will be put on the ballot for November. We passed the referendum to be put on the ballot, 1% sales tax in addition to what we have. And that 1% would go to new construction of schools and debt service on schools construction in the future. A preliminary thought is we have about, I think the number is 400 million in retail sales that would be in this group, which means there would be approximately $4 million would go towards education and towards the construction of schools. The other thing was we also voted 3-2 on the application for rezoning from industrial and economic and agriculture to all entirely economic opportunity on behalf of the Curtis Group. And that was a big portion of the meeting. And that's it.
Thank you, Mr. Moyer.
You're very welcome.
Item number 13 is Commissioner's Report, and I will start with Ms. Rose. Do you have anything for the Commission?
Not at this time.
Thank you. Mr. Davis.
No, nothing from me either. Thanks.
Reverend Hathaway. Ms. Townsend.
Yes, sir.
Thank you.
At this point, I would like the board to maybe take in considerations. We've had several applications come for us, the CUPs, that actually has not produced. I would like to make a suggestion that we do a standard expiration date on it. If, say, for instance, an application does come up and nothing happens within the 5 years, it does need to come back to be reviewed. I noticed that there was a couple of businesses that have applied for CUPs that have not produced anything.
This has been a topic we've covered before. I think, if I may, Mr. Zhang, if I could ask you to look into, number one, as a commission, can we suggest a sunset clause on the activity for a rezoning or a special use condition or a conditional use condition so that it doesn't remain active forever and ever and ever? I'm not asking for an answer tonight,
Yeah.
but if you can investigate that for us.
Certainly, and I can present a report back to
Please.
the commission at the next meeting.
Okay.
Thank you.
The other item I'd like to do is I attended some meetings and took some notes on certain things that had transpired, and I'd like to sort of share them with you. Says after reviewing notes from my meetings, comments on social media, verbal conversations, I'd like to make the following suggestions and consideration when writing the ordinances for the TOD. I know that Josh had said that he was going to start putting something together, so I would like to have some input of items that we could add to it. Number one would be maintaining the rural character as an important factor. Keeping this in mind, setbacks should be far enough from the main road that you cannot see this development. This would also apply to the sides and to the backs of the properties. Buffers should have a high and low height, which meaning If you have a loblolly tree that is high, you can see through the loblollies because all the growth is at the top. So when we're doing buffers, we want a dense buffer, so there should be foliage that's going underneath it so you can't see through it. This would also screen for noise and assist with the unseen items. By some chance, if a power station was to be created in behalf of a data center, it too would need to have setbacks and buffers to keep the rural area. All water that's used for cooling would need to be gray water, which would be purchased from New Kent County. A report on cleaning the water from the data center should be sent to the county for review. This should include where the water is being released, who cleans it, and what they were looking for in their samples. In addition to the energy that's needed, would suggest solar energy would also be required, utilizing some of the spaces on tops of the building. All generators should be placed in containers to keep the sounds low. Other suggestions that came across verbally in social media, which is not from me, but I wanted to also share with you. No tax incentives. All utilities must be paid for by the data centers. Now, this one I'm not sure how we regulate it, but noises shall be less than 50 decibels between the hours of 6 p.m. and 7 a.m. When we're looking at decimals, though, I know that if you're cutting grass with a push mower, that's 80 decibels. So 50 might be a little unrealistic, but that would be just something for you to take a look at. The following part would be limit on the sizes of the buildings. Now, I would hope with the rest of my commissioners would also want to make some suggestions, because I think more information that we give, everybody, when you start putting pieces in, add to it, and it makes a stronger piece of paper here. But I would like to submit this to y'all, and if you would just take in considerations, and if you have any questions, don't hesitate to contact me.
Just as a reminder to commissioners, the staff is still currently accepting suggestions for any kind of ordinance regarding technology areas or technology zoning or uses. So you're still able to provide them with email regarding that. Okay? You had a question, Mr. Irvin Hathaway?
Yeah, just a comment. In looking at the technology overlay district, we focused our attention on data centers, but that may not be the only thing coming down the road.
That's correct.
And so I think we need to really look at that very closely.
Thank you very much. You're absolutely correct. Mr. Dombrowski, sir.
Nothing at this time.
Thank you for hosting Ms. Pearson's town hall.
You're welcome.
Ms. Johnson.
Not at this time.
Thank you. Ms. Thomas.
I don't have anything, but I would like to make a statement. All of the recommendations that I will make, I'm going to make it through. I'm going to have someone else to send my recommendations for me, because I want to make sure that they are conveyed properly. But I will have someone to make the recommendations for me, because it not only impacts me, it impacts the citizens, it impacts where we live in District 3 at the lower half. It also impacts businesses, all of the businesses in District 3.
Thank you, Ms. Thomas. Mr. LaRochelle, sir, Vice Chair.
I'd like to thank the county attorney and principal planner for the presentations you did tonight. I think it's very useful, and I would love to incorporate some form of that in all of our meetings where time allows. Pick a topic, and there was a refresher or whatever else. I thought that was very useful, so thank you.
Yes, Mr. LaRochelle, and this year, and Mr. Davis earlier, probably year before last, or maybe even last year, when we meet with the county staff, we had a kind of suggestion that have the county attorney present at these meetings and maybe him presenting information as kind of a refresher as our duties or our rights or what our allowances are, just to keep us current on things, and also to bring in any kind of new legislation that may be considerable, for us to consider in our decisions. So I appreciate Mr. Zhang doing that for us, and I welcome his attendance in these meetings. That being said, I'll move on to staff reports. Item number 14, Mr. Raggi or Mr. Silva? I'm sorry, sir. Well, then, you know what? We'll move to item number 15 just for that. The meeting for our next Planning Commission meeting, we'll hold the regular meeting on Monday, August 17th at 6 o'clock in this boardroom. Unless I hear some other item is necessary to discuss. Do I have a motion? So moved by Mr. Moyer. The time is 8:13. Thank you very much, everybody, for attending. Yes.